Any mention?
Please, Your Lordship. Lordship, I beg to mention item number 8. Lordship, I pray for 2 weeks' time. The conducting counsel has some personal difficulty.
I'm for the respondent, my lord. No objection.
8. The request of Rani Council petition after 2 weeks.
Obliged.
Obliged.
My lord, I beg to mention item number 11, my lord. That's the 2 weeks, my lord. 2 weeks.
No issue.
11 also.
Obliged.
Obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 2.
Yes.
Number 2.
Yes, Your Lordship. As the conducting counsel is on bereavement, is in bereavement, the conducting counsel.
Bereavement.
Yes.
Then we will release it from Pathar.
Mr. DM.
Is there any use keeping it Pathar, Mr. Shula?
I don't think so, Your Lordship.
We will release it from Pathar. When you want it.
I'm praying for 2 weeks' time, Your Lordship.
So there is no, we will release it.
Lordship.
Yes, it is submitted that the London Council for the appellant is in bereavement.
Next week, Your Lordship, please.
You say 2 weeks now and next week? No,
Let
that
it be
means
next.
your
Let
thing is
it be
not-
2 weeks. Let it be 2 weeks.
What is it? Is on bereavement.
I'm not sure.
Stop. Matter was heard
She's in a same condition.
at some length
Common condition.
on such and such day. Just last it. It is prospect for further hearing. Stop. Today prayer has been made on behalf of the appellant to adjourn the matter for 2 weeks. In view of the prayer, the matter is released from Pathar. Released after 2 weeks.
Obliged, Lordship.
May it please your lordship.
Yes.
Lordship, I beg to make a mention of item number 4. No objection, Your Honor.
Item 4. 2 weeks.
Lordship, a similar prayer for item 5.
Yes, madam. 5 also 2 weeks.
Lordship,
The prayer of petition, both the cases.
highly obliged, Lordship.
Yes.
Item number 1.
May I please, Your Lordship? Can this matter come up at the end of the board, Your Lordship?
But will come tomorrow also, Your Lordship. Come tomorrow then.
At the end of the board, Your Lordship.
Yes, let us see. Just pass it over for the timing.
Lordship, yes.
Highly obliged, Lordship.
Just call it sometimes.
Hearing item number 3.
Yes.
Lordship, in this matter, we were supposed to get instructions on on whether the petitioners are still interested in going ahead with this matter. Lordship, we have been unable to receive those instructions because we have found it very difficult to get their contact, the petitioner's contact, Lordship. Lordship, I'm praying if this matter may be listed after a week.
If you have difficulty in contacting the petitioner, that means
Lordship.
they are not interested. We will dispose it off.
Lordship, if
They are not
may,
interested. It is their work basically. They should
Lordship.
come and
Lordship, if this call may
see,
be,
nothing remains is made. That is with regard to all those contracts which have long expired.
Lordship,
Why should we keep it pending?
because of the Lordship in this matter, there's a absence of policy, Lordship.
Doesn't
If
matter.
Lordship may be,
All your other grievances you filed in representation to the government. So far as this case is concerned, and especially all your members are not identically situated.
See the last chance.
Lordship may give a last chance, Lordship.
It's difficult, madam. You see, like it's pending right from this thing. The court had given the indication.
Lordship.
See, thereafter should have been, see, it is pending from the last year. Just for one instruction.
Lordship, a last opportunity may be given.
After tweaks from the request made on the record.
Obliged, Lordship.
Item number 6.
Yes.
May it please your Lordship.
Yes.
Lordship, in this case, I'm appearing on behalf of respondent number 7 and 9. I'm praying for some accommodation, Lordship, in this matter as well. Senior Conducting Counsel has personal difficulty, Lordship, appearing before this court
What is the
today.
matter of Mr. Khan?
My lord, in this matter, what has happened that I was appointed in the
Is a school teacher?
Regarding the school teacher.
school teacher. So
In a aided school or in a government school?
No, SSS school.
SSA school. So my appointment was initially I was working in one school, and thereafter I was transferred in the other school. But what happened that the managing committee had taken a resolution terminating my service, and
In the
thereafter
other school?
not in the other school, in the first
Original school?
Yes.
Original, yes.
And at present, then there was an inquiry, spot inquiry regarding my
Can there
conduct.
be a transfer from in this thing, SSA, under the SSM scheme? Can there be a transfer
No, my lord.
from one school to another
No,
school?
there is no procedure.
So then there was inquiry against me to conduct an inquiry as to
After dismissal?
not dismissal. I am presently working in the other school, SS school, but in the other school. In the other school,
Which way you aggrieved there?
I am aggrieved in the sense that there was an inquiry against me, and the first inquiry report said I am to be reinstated in my original school where I was teaching. Thereafter, again there was another inquiry, and that inquiry was conducted.
How
that-
inquiry can reinstate you? Inquiry can give you a clean sheet and all. Can they say you are reinstated?
It is mentioned that for after
Will it be binding?
yeah. Then thereafter, what happened? Another inquiry was conducted, and these two inquiries were they contradictory to each other, and it was conducted by the same officer. So I have come and challenged that inquiry.
The inquiring authority is government authority,
Yes, sir.
the state authority.
The state authority. I have come to challenge that.
So what role the private respondent has here? Now,
You know, I was removed when I was removed from the. When I was appointed. Thereafter, when I was verbally asked to join the other school, and in the meantime, the list of sanctioned teachers came out, where my name did not appear. The name of respondent number 9 appeared as a sanctioned teacher. But I am appointed as a sanctioned teacher. I am claiming
you are serving till now.
I am serving him.
Then what is the problem? Then
I am serving him. My only grievances is this, that I am to be given back my transfer to my original school, and the inquiry report that has been conducted against me is to be set aside because fresh inquiry may be conducted, because these two inquiries was conducted by the same officer and they are contradictory. The first said that I am to be reinstated. I am to be reinstated as a sanctioned teacher against the post which is being held by respondent number 9. Now, so my grievances is not that, it's limited to set aside that inquiry report. Fresh inquiry may be conducted.
What a fresh this thing, my lord. The first school is
what
as
role
per.
private respondent has here?
Yes, no, I am from the government.
No,
But,
that is okay. What role
They
private
also did
respondent
admit
has here?
that was
They
contrary.
have.
no,
Inquiries by you.
yes.
They are not required, I think.
But problem is that, my lord, the first school, as per the allegation made in the affidavit, that he was terminated. He was appointed on contractual basis for 1 year. Within 6 months, he was out. He has terminated from the
So
service.
it was not a case of transfer.
No, no.
No, basically, my termination was illegal because it was done behind my
That is
back.
okay, but then you said it's a transfer. There is no transfer there.
No, in fact, what has happened that when I was verbally transferred to the other school, the school in which was
Verbally transferred.
verbally. No. So when I was walking the first school, that what has had happened that my service was they are claiming, the managing committee has said that my service has been taken. We are challenging that termination also because it was done without following due procedure of law.
And that also they have come after a lapse of 4 years. My
You
lord.
know.
After 4 years of termination.
Yes, yes.
Is there any explanation for that delay?
There is
No, in
nothing.
fact, at the first instance, when the writ was filed, we had not challenged the second inquiry report, and subsequently another writ was filed this instance, and then we had challenged that second inquiry report.
In fact, nothing is survived, my lord, in this petition, according to me.
Yes, madam. If you do not have a direct rule, then it's okay. Why should we adjourn this matter? What role you have here?
Lordship.
And our prayer is that I may be taken back to my original school, and the respondent number 9 who has been working there, he may be transferred there.
First, let us see whether they have been transferred or not. The question of taking you back there will arise here. Where is the question? If you have the verbal order of transfer, how
There
it
is
will
no
be?
official order, my lord. As per they are alleging that the CRC, Cluster Resource Center, this in charge, has verbally tell him to join in this other school. That is their allegation.
That is their
But in fact, this present CRC is his affidavit is already filed. He is denied it. There is no record in the school for
which-
transferring.
Then which way will decide this, Mr. Khan?
My only thing is that the inquiry report against me, because the first inquiry report which was conducted has specifically and categorically said that my termination was done without following due procedure of law. My termination was done without following due procedure of law by the managing committee of the school, and then they have categorically mentioned that, and thereafter, well, it is at
Your appointment is for 59 days.
Yes, my lord. In 2010.
Then
The question of giving opportunity does not arise here, my lord.
of course, but so we are challenging the inquiry, the manner in which I am being
your appointment is for 59 days.
you know.
Then what right it will give you? See
Yeah.
annexure to page 15 of the
Yes, sir.
petition.
But at page 31, where the first inquiry report, typed copy is at page 31.
Where is your termination order?
Let's
Text number 24.
24.
Annex of
It is mentioned in that page 24. Sorry. That in my place, with reference to
Page 24.
24. Annex 10.
Yes. This in 2016.
My lord.
No, this is what? This is a letter by somebody else.
No, this is a letter given by the managing committee.
This is page, you are referring to page 24.
24.
Annex 10.
Yes, sir. This is a letter given by the managing committee to the district mission that since I had prayed for revocation of my
Reinstatement order.
reinstatement.
They have asked for where is your revocation order?
No, that is at page 30, Annex 13.
Page
Page
30 is
30.
your affidavit.
No, my lord, page 30.
30.
Page 30.
That is a reinstatement. Where is
Well,
the revocation?
It is in pursuance of that inquiry report dated 1/11/16.
That is okay, but where is the where is your this thing? Where is your removal order?
My lord, in fact, the in fact, that page 24 reflects that. Page 24.
What is the order? This
Because
to see. There is no question of
My lord, he was terminated from his job by resolution dated on the basis of the resolution.
So where is that? We want to see it.
On the basis of the resolution, my lord. So that order. In fact, only that annexure 10 reflects here, because it is based on the resolution passed by the managing committee that my service has been terminated. That is on. At page 25, that is a type copy.
Why this response number 8 was struck off?
My lord?
Why the response number 8
Yeah.
was struck off from the area of parties? Who is response number 8?
Respondent number 8 is the managing committee of Malidas Para School, where
Yes.
where I was being transferred orally, where I'm working now.
Yes.
I've been working there. In that.
So why this school has been struck off?
In fact, because our grievances is basically against the respondent number 7, managing committee, who had issued the order of termination. Right.
Where is your transfer? When did you join that in that school?
Well, it is mentioned.
Where?
Annex 3, page 16.
What is that?
Here it
This
is.
thing is your joining report.
Yes, this is the joining report.
Where is your transfer? After transfer, you have joined in
My
the
lord,
school and all those things.
I was already transferred verbally. I was fully transferred. Basically, and after
You have
completing,
already joined. When did you join in that school?
my lord, I had joined the school on that school.
And you have struck off the name of this restaurant number 8.
Yes, Your Honor.
Who will substantiate those things? Those claims by you.
My lord,
If that school is not there, how can you say that you have gone and joined there?
my lord, I was just already, I was already asked to
Then
join,
your-
and I joined on 1st June 2011.
Huh?
1st June 2011 and working there till
Where is
now.
that stated? Where is that stated?
My lord. Para 5, my lord. Page 5 of my petition.
Yes.
The petitioner begged to state that after having performed his duty as assistant teacher at Kunalgati for almost 1 year, all of a sudden the petitioner was asked verbally by the coordinator cluster resource center Mahendragan respondent 6 to join as assistant teacher at Malidas Para SSA UP school, and accordingly, in obedience of the verbal order of the said respondent 6, the petitioner joined his duty as assistant teacher at Malidas Para SSA UP school, and at present working as assistant teacher in the school. This fact is seen from the letter dated 9/8/2016 issued by the headmistress Malidas Para school, which is annexure A6.
Come, annexure 6. You can annexure 6.
Malad, should I read?
What is the till the date means?
It is mentioned, "This certify that Salim Khan, son of so and so and so, is an inhabitant of village so and so, Southwest Garwal. He is doing his duty till date of 1st June 2011 to 6 August 2016 as assistant teacher in the said school. His date of birth so and so and so, to the best of my knowledge." So it is mentioned that I have joined since 1st June 2011 to 6 August 2016. I'm still
So after 2006 August 2016, you are not working anywhere.
no, I'm still in the school. I'm still in the Malidas. I'm still working in the Malidas Para School. Now the only grievances here is that on this, the managing committee had terminated my service when I was in the.
You are not at all now related to that managing committee. Which way you agree?
No, my lord. The thing is that now at this stage, my prayer is that I may be allowed to join my previous school where I was working.
Why?
Because of the sense that at the initial point when I was working there, and thereafter what happened when the list of sanctioned teachers came out, my name was not there, and the name of the respondent number 9 came up, and still then I was working there. Now that there was an inquiry against me at the first inquiry on the basis of the complaint, then the inquiry report reveals the fact that I am to be reinstated in my first place place where I was working in the Unarkati school. And subsequently, when the order was on the basis of the inquiry
report has not been given effect to. What is the problem? You are serving in the school.
report,
When you have voluntarily joined in the other school, if at all you are transferred,
my lord,
then why should you go back to your original school now?
my lord, the only thing is that the managing committee, which has passed the reason that they have terminated my service, I was allowed to join, but they are refusing me to join. They are not allowing me to join that previous school. Now the only thing is that the first inquiry report that was conducted allowed me to be reinstated and join in the first place. And subsequently, another inquiry was conducted by the same officer, where they have taken a contrary stand. The government is also admitted to that.
You are again going by inquiry. What bearing this inquiry has on you?
Well, the thing is the only thing is that it is on the basis of that second inquiry report also I am affected.
What is the date of the second inquiry report?
Second inquiry was that was 29 March 2017, page 41.
And then what happened in pursuant to that the second inquiry report?
Well, if I'm allowed to read para 4. That, Madam, as per the observation and verification, Salim Khan, his appointment is done by the school managing committee.
What you are reading? What you are reading?
Para 4 of page 41.
Page 14.
41.
41. Okay.
As per my observation and verification, Sri Salim Khan his appointment is done by school managing committee. He had been appointed as fourth teacher in the school, and track appointment has been done on 1st April 2010 between the school managing committee and the teachers with the countersigned signature of the district mission coordinator, SSA West Garwals. It is also observed that the appointment letter and joining report has been so and so. They have tampered and closed for your reference. Then
Tampered by whom?
well, that is the thing. All these discrepancies are there, and the last.
What action has been taken on the basis of this inquiry report? What action the state has taken?
But I don't think so. No action has been taken.
Then it's okay. Let it remain on record.
Fact remains that the two inquiry report. The first inquiry report had revealed the fact that I am to be reinstated in the place where I was working, and the second inquiry report gives a contrary view, which the state is admitting.
Here says that you have voluntarily joined in that school only for your own accord. This is second inquiry. See the last paragraph. Come to page 42.
statement given by Salman has been transferred or verbally sent off by this one, so and again to work as assistant teacher my school, and is willing. He has joined. So, no matter the only thing is here is that at present the inquiry report, which is contradictory, we intend that this inquiry report, it needs to be quashed. I am to.
There is no cause of action for quashing this. Why should we quash?
Because
what report this
in
report
fact
has reported
Yes.
nothing.
In
No
fact-
action has been taken against you on the basis of this report.
In fact, my term.
This second report, does it say that you should be terminated?
In fact, the report does not say that it is terminated, but it is our only grievances
That
that
is
we
good enough. You were there at the time of inquiry. You were working in some other school. This report also confirms it. Says that willing pulling you have joined there. So what remains? There is no cause of action for this case. Why unnecessary?
basically, what we are challenging the termination that of
What
the
happened with
school.
these inquiry reports? Which way has it been acted upon or not?
No, no, my lord. It is not acted upon.
We'll record and finish. Things will remain as it is.
And moreover, in the Annexure 6, my lord, they have mentioned 2011 to 6 August 2016, he is working in Milan Das LP school, my lord. And that is also, he is willingly accepted in the inquiry report.
That is all right.
Yes, my lord.
That is all right. And he
No,
says
but
that he is
inquiry
working
report
there.
is not acted upon, my lord.
If he is working there, then what remains? There is no
Yes.
grievance. There remains no grievance.
Salary is the same, my lord. Both are SSS school.
It's okay. It's 2011.
But-
he has gone there. Now
Yeah,
we are
but
2024.
my lord,
It's 13 years.
my appointment was when the first inquiry report it revealed my appointment was it was on the sanction post. Now where I'm working, it's not a sanction post. I've just been.
How do you say it is on the sanction post? How do you say? Earlier appointment. If it is there, then why you have gone to the other school? Why you have joined in the other school on transfer? If you say so, then why did you accept your transfer?
My lord, I was just orally asked to go.
Whatever it is, you have gone there.
I was just orally asked
If
to
oral,
go.
oral order is good enough, why written order is
And
not
then-
needed? Where it is said that you are in a sanction post?
No higher, my
But
lord. No higher. In the petition also. There is no such order, my lord.
This is all right.
My lord, that is at page 32A.
A.
Yes.
So your sanction post is only with for 14/12/2016.
My lord, submitted that the undersigned is directed to reinstate Salim Khan as assistant teacher in the Kunargati SSA UP school as sanction post with fixed pay so and so,
Then read
With it.
complete.
with effect from 14/12/16.
So that is all.
14/12. So it is on the basis of this that this order that I am to be taken back to my original school as a sanction teacher.
Your appointment, original appointment was not on sanction post.
Well,
The post in 2010,
Correct.
it is not on sanction post. It is with effect from 14/12/2016.
yes, my lord.
Now after 14/12/2016, why did you join?
My lord? No, I am still working in Malidas Para School. My prayer is that
How can you be, and you have accepted this? You are working in some other school, and now you say that you are appointed in sanction post in some other school.
my lord, so
Now,
far,
pursuant to this, where have you joined? Pursuant to this.
yes, my lord.
32A.
Then a letter was sent
Yes.
allowing me for joining. They had refused me to. They had refused.
Where is? Then what action you have taken against that refusal?
That's what we have come before this honorable court.
When it means you have come. When did you file this case? In 2020.
20.
After 4 years, you have come to challenge your non-joining. How can court will believe those kind of stories?
So, my lord, there was corresponding in between.
That is okay. If you are happy with correspondence, then remain with correspondence. Now also. Then who is what issuing what order? Who is not? Very surprising.
And annexure 16, page 34 also, where I had, after I was allowed to join in pursuance of that letter, they had refused.
Where do you stand now? Just tell us. If you claim yourself to be a teacher of Kunarghati school,
My lord.
then how you are serving in this school?
My lord, the only thing is that when I was asked to join verbally to in the Malidas Para school, then subsequently what had happened, the managing committee of the Kunar Ghati school had, without any following the procedure of law, had terminated my service. They had terminated my service, and subsequently, after termination of my service, I had made the correspondence. Thereafter inquiry was conducted.
When your service was terminated?
Well, the just a minute. 20th 6 2011.
2011.
Yes.
Have you challenged the termination order?
Yes, that is also challenged
Where?
in my prayer. I have
2011 you have
No. Yes, because
prayer.
my lord, what had happened, I had just reiterated the first instance we did.
See, why your things 2011 if your service is terminated, thereafter you were working in some other school.
My lord, I was.
So then think that grievance you cannot raise now. Admitted position is that. Now tell us, what do you claim? Where do you are a teacher of which school? What is your claim? Just forget about what the other says. Tell us what is your claim?
At present, I am working at Malidas.
Not forget what is the present. Legally, where should you remain?
Legally, I should remain in Konarghati.
Then why did you work in that other school for 6 years?
My lord.
Your conduct is something very questionable. If you claim yourself to be a sanctioned teacher in certain school, how could you work in some other school without raising any grievance? Without approaching court at the appropriate period of time? Then thereafter now you are relying on a letter in 2016 wherein it is said that you have to resume your duty as a sanction post in 14/2 of 2016. Now if that be the thing, how could you work in some other school? Irrespective of the fact whether you are allowed to join or not, you are not allowed to join, you remain a teacher of that school. Then how could you serve in some other school? Is it not misconduct? You are trapped by your own case. Your own assertion, you are trapping yourself. Because at this moment your very statement is that you are working in some other school.
My lord.
Then
That is the only.
that is, see, your transfer, your everything goes after issuance of this 2016 letter. You should have been legally serving there in that school. You do not do it. You serve in some other school, and now you are fighting a case just as a time pass, nothing else. Because if you claim yourself to be a teacher of Kunarghati school, how could you serve in some, how can you serve right now in some other school?
My lord, that was the only
That
point.
is a ground for dismissal. Your service should have been terminated on that ground alone. Nothing more is needed. You want this court to pass some order, or just see what would be in your in the interest. At least from this court, you are not getting anything. Rather, it will complicate your things. This court finds your conduct very questionable. We will forget all other things. We will forget your appointment, your things. We will, if we start from 2016, and on the basis of that 2016 letter, treat you as a sanctioned teacher also, then how you will explain your present conduct of working in some other school? And that is good enough to dismiss your case. We do not have to go to any other things.
We just allow some more time. Let's see. My lord.
What you will do? You take instruction, that is
I'll
better.
take some instruction in there.
Talk to your things. You see, like unnecessary pursuing.
My lord.
If you do not get relief, rather if it aggravates your things,
My lord.
that will not give any relief. See, your conduct is basically one thing because of which you have spoiled your own case. Hard, so and so. Just write all the parties. At some length, Mr. A. Khan, Lord Counsel, that you have the petitioner submits that he would repair some instruction, some more instruction for the petitioner, especially with regard to whether this petitioner is still interested in pursuing the case or not. The London Council has paid for grant of some time. Prayer allowed, distracted 2 weeks. You just see, if you think over, you see, you can understand, you have a long standing in this profession, at least see the things, which way it can be done.
Item number 7.
Yes.
Lordship, I'm praying for some time in this matter, Your Lordship. I'm praying for some time, Your Lordship.
What is the matter about, madam?
Your Lordship, this matter is regarding disconnection notice which was issued to the petitioner, and thereafter we had prayed for 100% waiver of DPC. And after that, the matter was
What is the
referred.
DPC? This is Electricity Corporation.
Electricity matter.
Non-payment of dues.
Non-payment of dues.
Are you disputing the rate?
Your Lordship,
Are you disputing the rate?
we are disputing the rate, Your Lordship, because after the matter was referred to Lok Adalat, it was the award was passed stating that both the parties are to settle the matter. After that, the respondents never sat with the petitioner, and then COVID came in between.
Whether you are disputing the rate or not, and if you dispute, which way this court will settle it?
Your Lordship, we are disputing the rate.
So how this court will settle it?
Your
How this
Lordship,
court will say what is proper rate and what is not proper rate?
Your Lordship, in the meantime, after that, we had proposed for 36 installments for payment of the rates. And
These
then,
are, is it for this court to consider all those things?
Your Lordship, in the meantime, they had come up with this one-time settlement scheme. After agreeing that there will be 36 installments, they had come up with the one-time settlement scheme.
So
So for that reason, Your Lordship, we are coming here.
they have come with one-time settlement scheme. The scheme is not specifically for you; it is for everyone, isn't it?
Everyone, Your Lordship.
No, that so
But-
far as your agreement
But
of
before,
payment,
Your Lordship,
that remains. That would be something separate from the scheme. The scheme will not take away that settlement, isn't it?
Your Lordship.
Then
But Lordship, here the problem is that before the scheme came up, we had an agreement where we will clear the dues in 36 installments because the amount
that
has
was
come
duly
up in
executed by the
crores,
parties.
Your Lordship. And then they introduced this one-time settlement scheme.
And then, if that agreement is violated, where do you have your solution? In a writ court.
Your Lordship.
No, nobody's from the other side.
No, Your Lordship.
Right, Hanni. So it appears for the petitioner. None appears for the respondent. Any likely of settlement of this matter? No.
There might be a Lordship because there are so many times both the parties had approached for settlement.
Learned counsel for the petitioner. Please for grant of some time. We are allowed list after 2 weeks.
2 weeks, Your Lordship.
See, madam, this kind of things I do not know to what extent writ court interferes. You may have,
Lordship.
maybe in some courts you may find that courts interfere, but in this court normally, in agreement matter and all those things, not very inclined. Your remedy lies somewhere else, probably.
Your Lordship.
Just verify those.
Highly obliged.
Item number 9.
Yes.
Please, Lordship. Lordship, I am praying for some accommodation, Lordship.
This is a new matter, 2023 matter.
Lordship.
Lordship, I've got an objection, little mild objection to that. However, since my friend is asking, I have put an instruction, Your Lordship, that the accused petitioner there have rented out the top floor and the ground floor where they are now residing. They are contemplating to
What is the matter
dispose
about,
of.
Mr. Chaudhary? You see, like
This is a
until
criminal
this
matter,
court-
Lordship. This is a matter against the petition is filed against the proceeding before the learned judicial magistrate Shillong.
This is a criminal petition. This
Criminal matter.
My Lord, it's a civil petition, my Lord. It should have been a civil proceedings, but my Lord, it has given a criminal color, my Lord.
No, Lordship, that is
It's
not
a
that. Not
complaint.
is
Yes, Lordship.
They are receiving quashing of the debt.
Lordship.
Process has been issued.
Lordship.
no. Everything is only for hearing, Lordship here. And in this case,
Not talking about this case, just talking about what has happened. Till what extent it proceeded in trial court. Process was issued.
Yes, Lordship.
And thereafter you have challenged this,
Lordship.
saying that this is a civil dispute.
Lordship.
This case has been registered under what section of law? This 120B,
120B, 420,
418.
406, 418, my Lord.
And what is the allegation made in the complaint?
Basically, my Lord, one power of attorney was executed by the, my Lord, respondent herein to execute certain task, my Lord. Pursuant to that power of attorney, my Lord.
in respect
Yes,
of certain property.
certain property,
It was
family
a general
property, my
power
Lord.
of attorney or special power
General,
of attorney?
general power of attorney, my Lord.
General power of attorney. Now
In terms of that, my Lord,
you were given you have appointed as attorney.
Lordship.
Yes. Then
In
what?
terms of that, I have acted upon. Subsequently, my Lord, in the year after the lapse of 8 years, they have come and, my Lord, revoked the power of attorney, my Lord, after the execution was done, my Lord. I have already acted upon the power of attorney, my Lord.
That's okay. Power of
Yeah.
attorney. This is the legal
Lordship.
Is there any law which says that cannot be withdrawn?
No, it can be written, but my Lord, after everything was completed, my Lord,
Do you want to say it was for valuable consideration? Power of attorney.
no, my Lord, for execution of certain work, my Lord.
Anyway, so it can be withdrawn. What is the problem in withdrawing? They have-
But my Lord may kindly appreciate here what had happened. After the work was executed in terms of the power of attorney, my Lord, given, subsequently, knowing fully that, my lord, it has already been executed, then, my lord, later, at the later stage, this power of attorney was, my lord, revoked. Otherwise also, my lord,
It was
otherwise,
revoked.
yes, yes, my lord.
And now, what is in criminal cases filed in what connection?
In that connection also,
It means like during the time when this power of attorney was valid,
my lord,
he performed some
task.
function.
Yes, my lord.
Yes, on the basis of the power of attorney. Now, this is it that they are saying that this is this criminal case which was filed against you.
My lord.
What is the allegation made there?
My lord, here the allegation is that, my lord, we were given some tasks to be done, my lord, in terms of the power of attorney, that we are like
No,
on this
how come
date.
this 420, 406 and all those things come?
It,
It means there is an allegation of cheating or maybe forgery or something like that.
my lord, that is their projected case, my lord.
Whatever it is. Now, how can you term it as a civil dispute?
My lord, here the issue is only with regard to money, my lord. The money.
How 420?
It's a family property. It's concerning the family property, my lord.
No. This is
Business, family property. Then there they had a property. That property, my lord, it was given to the petitioner herein. In terms of the power of attorney, my lord.
Lordship, we have filed shokos. Lordship was pleased to allow us to file a shokos.
Yes, we'll come to you, Mr. Chaudhary. Just this court is basically trying to get the fact.
Lordship.
Nothing else. Right now, this court doesn't also want him to make a submission on merit.
Yes,
Only just for the purpose of determining the fact. Now, he was a power of attorney holder.
He was a power of attorney holder, no doubt, Lordship.
No,
but after having taken the power of attorney, he has constructed four-storied RCC building at the.
He had the authority to do it.
Yes. What happened? He came to Shillong and he proposed that I am having a land at Delhi, and why I am keeping this land back and there. Now, if this land is given for to a developer and raising structure, then developer will take two flats, and your humble respondent will have 2 flats. Now, after giving these 2 flats to the developer, the accused person they approached.
Where is the location of those flats?
In Delhi, Lordship.
So why the case is here?
Case is here because
only the
the respondent is taking that the petitioner here he has lulled her and said that his very attitude from the beginning was to cheat her. So she has been approached that you do this, and after going there, what happened, Lordship? He has done at this at the advice of or the instruction or the what was discussed, reached the structure, and 2 flats were given to the developer, and 2 flats, top floor and the ground floor, will remain with your humble respondent here. Now, the instruction was that top floor he will sell it, and the ground floor your respondent will take possession. Now, meanwhile, what happened? He came with a proposal that where he is staying now, his landlord is saying that he is to vacate the house, so his accommodation, so he may be allowed to stay in this respondent's ground floor. So in the ground floor, she said, okay, you stay. No rent, nothing, of course. Now, when the question was that you vacate this premises, then he said this plea, that plea. Ultimately, when he was unable to sell the top floor, then your respondent, what happened, contacted a person from Shillong to Delhi who was willing to buy the top floor. There, what happened, when that person, one Mr. Jha, approached, this respondent was not cooperating with him. In that case, what happened, this respondent's doubt has arisen that this gentleman is doing something hanky-panky there. So she deputed her husband and son there, and the son and they are having their own relation also in Delhi. So in a body, they sat in that flat itself where these petitioners are staying. Their discussion, he said that, no, I will not give this, you will have to pay me 1 crore rupees, this and that. Then this lady has understood, your humble respondent, that he has, from the very beginning, his nefarious attitude is to deceive him. So since his bad intention, it has started, this crime has started from Shillong itself. And it has resulted, this was consequences there. As such, under section 178 read with section 79 of the CRPC, see, this proceeding was launched here. That deceiving attempt on his part is from the very beginning. That is the reason, Your Lordship, this some ancestors. Now at this stage, what just I have at the beginning submitted, that he has given the top floor on rent basis, and the bottom or the ground floor where he is now residing, he is contemplating to sell it out, and that is the reason why the matter is delayed. That is the matter is delayed here. So, Lordship, if your Lordship goes through the shokos on 17/8/2023, we have filed, we have given the detail, and we have met each and every point. The resident, that this is a family matter, I have met it, that it is filed at a delayed stage, is a delayed stage, that I have also met. Rather, we have taken a plea that this petition for a criminal petition is filed at a delayed stage beyond limitation. That is to be filed within 60 days as per section, Article 115 of the Limitation Act. They have come after 10 months.
482.
482.
482 within?
Not 482, any petition, I mean, here petition. 482 may be a special provision, but any petition to High Court should be within 60 days, Lordship. So these things we have just, when we...
Isn't it?
Yes, Lordship.
Revision.
Revision.
I understood, Lordship. So, however, we have given in our Shokho's reply,
the points which
in
my lord
detail,
has
Lordship,
pointed
given. Each point we have met.
So then,
the other point which my lord has rightly pointed out, that issue of duration also, my lord, we have taken the plea here. The only the point which the respondent has raised, the cause of action which they have shown is, my lord, the execution of the power of attorney here in Shillong itself, my lord. Otherwise, the other.
see, execution of power of attorney is by them.
Yes, my lord.
So no criminality can be attached.
Nothing, my lord.
At the initial, of course.
That is the only cause which they have taken, my lord.
They say this power of attorney, making of the power of attorney was influenced by your side.
Nothing is there, sir.
That is what we have to.
Yes, my lord. Nothing as such.
If there is nothing, then he cannot.
Absolutely, my lord.
He himself has chosen you to be your attorney. Okay. Of course, it doesn't mean that once you become attorney, you will do whatever you want.
Only to the, my lord, the frame of
but
the...
then so far as the cause of action is concerned, this will be necessary for determining.
Absolutely.
This is your case, that he has, if you say that the right from the beginning,
yes,
the petitioner had the intention of deceiving you. Did you say that this power of attorney was made at his influence?
Yes, that you stated. That you stated, that he has rather inspired her, that you, madam, kindly see that land is there. Why you have kept it? You do in that way.
And it took you 8 years to realize.
No, 8 years is not that. Because bona fide, I was expecting that the things will go. But when his attitude came to her knowledge,
so
that he is not doing as per her instruction.
That you are being cheated after 8 years.
No, not after 8 years, Lordship. That is a mistake. My friend has made a wrong submission, a mistaken submission. What happened? It has started from 2013. And since the respondent was pursuing the matter, but you kindly sell it out, the top floor.
When did you file this criminal case?
Pardon?
When did you file the criminal case?
We filed it, Lordship.
Which year?
2021.
2021.
Yes.
Very recently. Anyway, when do you want it?
My lord, may I have it after 2 weeks, my lord.
Mr. Paul is not there.
No, of course, he is not there, Lordship.
To counter
I have
you,
no,
Mr. Paul
in
will
that
be
sense,
needed.
I have no objection, because since a lawyer may have. But the question is that if your Lordship pleases to dispose of the matter a bit early, Lordship, because criminal,
See,
the criminal
if parties are ready, we can dispose it today also. If you want, we can hear it today also. You see, there is no problem. But then if you think,
No,
see,
in that sense, when any
if
time
you-
is sought by any lawyer
if you
friend, we
seriously
normally
oppose
do
to
not
stay,
make
then
any objection,
okay.
Lordship. Normally do not make any objection, except my mild submission that if it is kindly disposed of, because there is no stay here in this case, nothing. That case is lower court cases, date is given from time to time. We are attending the matter, Lordship.
Proceed with that one. You can always tell that court there is no stay.
Yes.
One request made on behalf of Mr. Oh, just say Mr. Panthi, Learned Counsel, ready for the petitioner submits that Mr. K. Paul, Learned Senior Counsel, is not in the position. He's not here.
He's here, he's here, my lord.
This is Mr. So and so, Senior Counsel, has some personal difficulty and prays for granted sometime. Prayer allowed. List after 2 weeks.
Deeply obliged.
Lordship, after 2 weeks, Lordship.
Item number 10.
Yes.
May please, Your Lordship. My lord, this is also another section 482 case, my lord.
Yes.
Here, my lord, no offense, my lord. Bhajanlal's one of the conditions, my lord, to abuse. Section 482 can be invoked to abuse to prevent the abuse of the process of law. That is one of the things. Now here, my lord, what happened? It's important to take little bit to the background, my lord. The petitioner before my lord is the ex-secretary, my lord. Is an ex-secretary of the Bharat Scouts and Guides, my lord. Bharat Scouts and Guides, and she is a 72-year-old. Now she is a 72-year-old ex-secretary of the Bharat Scouts and Guides. She has contributed for the welfare of the state and for the youths, my lord, immensely, for which she has got international recognition, national recognition. Which I mean to say that she is a lady of a unpeccable character, my lord. Now what happened is that there was the private respondent number 5. The private respondent number 5 was working with not exactly working, was volunteering for some time with the Bharat Scouts and Guides. Now my lord knows that the Bharat Scouts and Guides, there are two set of people who functions there. One is their own employees who are come with a regular advertisement and everything. Another one is a voluntary. Any of us can also go and volunteer now. So respondent number 5 was one of such person who come and help in voluntarily. So somewhere in the year, she has requested me for a certificate, experience certificate. So I have given her an experience certificate. Experience certificate saying that she has volunteered as a non-salaried person, so that wherever it might help, in whatever manner it might help her. So now there was an advertisement. There was an advertisement for filling up of the state organization or a state organizer in the Bharat Scouts and Guides. Now the criteria for that is that certain criteria were there. Like you have to have a 5 years of experience as an assistant state organizer, and all those criteria were there. And when these applications were put up, respondent number 5 along with other respondents other candidates.
This respondent number 5 also applied.
Yes, applied. She applied.
And on the strength of the certificate issued by you.
On the strength of certificate issued by me. Now, for now, we'll say that. So
no, we are just give us the facts.
Yes. Just
your version, you give it later. Just give us the facts.
Yes. So what happened was that when she applied, respondent number 5 applied, there were other candidates also applied who were actually the ASO, serving ASO, who were the qualified ASO, who were serving, who were employed of the Bharat Scouts and Guides. They found that this, because they know they are in the same organization. So how come she is not qualified to apply for this post, but yet how did she apply? So one of the applicant filed an RTI. Filed an RTI, and the RTI was allowed and to inspect the documents filed by other candidates. So then the other candidates found out that one certificate, which was one certificate stating that, experience certificate stating that she was serving from 2016 in a Bharat Scouts and Guides. So which is literally a false documents according to knowledge of the other candidates.
No, but then you said that she was there in the voluntary service.
She was there in the voluntary service, but not from 2016. No. So what happened is that after that, then this applicant, she writes a letter to me, the one who found out the false certificate, whatever certificate, wrote a letter to me asking clarification, asking me, madam, this respondent number 5 was never working here as an assistant state organizer for 2016. How did you give her a certificate of 2016? So I was shocked as a state secretary, because to my memory serves, I've never issued her that certificate. Of course, I issued her certificate, but not from 2016. And then after that, even the MPSC has summoned me. MPSC summoned me, and I went and told the MPSC that no, I have not. Yes, I have given the certificate, but not from 2016. From 2018, I have given. Now, the advantage of respondent number 5 for submitting 2016 is that because if she does not submit 2016, yes. If she does not submit 2016 certificate, then that experience of 5 years she does not have. But I gave her 2018. I went and told the MPSC, and now MPSC issued her a show cause notice. When MPSC has issued her a show cause notice, she came and filed an FIR against me.
File any FIR.
I did not file. Before I acted in filing any FIR, she has acted first and she filed an FIR against me.
What for? What is the
Now,
allegation?
in the FIR, what she has alleged in the FIR is at page 25, my lord. She has, may I just read this one, my lord?
Page 25.
Page 25, my lord. Oh, I'm sorry, not this page. Oh, sorry, page 30, my lord.
30.
Page 30, my lord, annexure 8.
Yes.
And that also she wrote straight to the superintendent of police.
So like, no.
And then she said, first information report, sir. In drawing your attention to the subject cited above, I, Srimati so-and-so, would like to bring to your notice that I have applied for the post of state organizer, scout and guides, white advertisement number so-and-so, dated 14th November 2019. I have been declared as eligible candidate for the post white notice number so-and-so, so-and-so, dated 23rd September 2021, issued by MPSC. To my utter shock and surprise, I received a letter number so-and-so dated 2nd February 2022 from the Public Information Officer MPSC informing me that the certificates produced by me before the MPSC suffered from discrepancies and directed me to show cause as to why action should not be taken against me as per rule. I appeared before the Commission on 04/02/2022 and produced the documents. I had also filed my show cause on 07/02/2022. In my show cause, I have made a request to inquire and call for expert opinion to verify the genuineness of the certificate produced by me. The then Secretary Meghalaya Bharat's counter guides, Srimati A. Swear, had issued me a certificate bearing number so-and-so, wherein it was stated that I was holding the post Assistant State Organizer since the year 2016. However, it came to my knowledge that Srimati A. Swear had approached the PIO of the MPSC by way of RTI petition and submit a certificate bearing number dated 09/03/2021, whereby the year of my service as Assistant State Organizer was recorded as 2018. From what it appears, the then Secretary of Meghalaya Bharat Scouts and Guides, Srimati S. is lying, is trying to blame and accuse me of submitting fake documents before the Commission so that I will be declared as ineligible candidate by the Commission for the reason best known to her. The fact is that I have been working as assistant organizer non-salaried since the year 2016, and that I precisely the reason why Srimati S. Swear had issued the certificate which I had submitted before the Commission. As to how and why the said Srimati S. Swear had prepared another certificate stating otherwise is very strange and mounts to misrepresentation. The accusation against me by Srimati S. Swear is not only defamatory but also has affected my candidature for the post I have applied for. In the circumstance, I would like to request you to kindly find out.
It has happened like that.
Yes.
Instead of filing of FIR against that girl.
Yes.
So that arrest number 5.
Yes.
For preparing a forged or manufactured.
Yes, manufacturing that. Yes.
Now FIR has come against you.
Against you.
And that 2018 certificate.
Yes.
Which you are saying that you have issued.
Yes.
She claims it to be that one is forged.
2000. Yes. Yes.
Okay.
Yes.
Now, one thing is that the certificate given by you.
Yes.
There is no allegation that 2016 certificate. Otherwise, what this MPSC has said, but then so far as the FIR is concerned,
yes,
or any police complaint is concerned, there is nothing to show that 2016 certificate was timed to be a forged one. So it stands,
Yes.
isn't it? The problem is with the second certificate which you claim to have, you have originally issued,
Yes.
showing that 2018 is the, we're just timing at 2016 and 2018 just
Yes,
for the purpose
yes.
of this. Now, this 2018,
Yes.
it stands issued by you,
Yes.
irrespective of the fact whether it is 2018 or 2017 or 2016.
Yes.
How can it be termed as a force? Because you are the author of it. So forgery cannot come here,
Exactly.
isn't
Exactly.
it?
Yes.
So how a criminal case can be instituted against him?
Exactly. That is why I'm here. I'm saying that.
Irrespective of the fact
Yes.
that what should be the correct year,
Exactly.
that is a different issue.
This is a different issue. Therefore, how can I forge my own signature? This is what she's trying to say.
They cannot say
Yes.
that it was done
Yes.
to help the restaurant number 5.
Yes.
In view of the fact that restaurant number 5 herself is the complainant.
Yes. Yes.
Isn't it?
Exactly.
Otherwise, they could have done that you have done something wrong.
Yes.
There could have been an allegation saying
Yes.
that you have done something wrong
Yes.
to help somebody.
Yes. Yes.
But then it is not your case.
Yes.
It is not their case also.
Yes.
So how can a criminal case stand against you?
That is the reason why, my lord,
What is the case section registered under this thing?
they have registered 468, my lord.
Forgery
468.
with intent of
Forgery
cheating.
with intent.
Who has forged? What they have forged?
That is what the
is the
respondent number.
forgery here, Mr.
This allegation has to go to the respondent number
Forget about
5.
the correctness of the forgery is something.
Yes.
You see, like I copy your signature, you copy my signature.
Exactly,
something
my
like
lord.
that, isn't it?
Yes, my lord.
Now, how 468 comes here? Mr. Gurung, my lord, this will be for you. See, this issue seems to be very this thing. The interesting part is that the recipient of a certificate issues FIR against the maker of the certificate,
My lord,
saying that the details provided therein is not correct.
my lord.
And this has been registered as 468. How can it be done?
My lord, the allegation here is, my lord, the actual picture here is that, my lord, that the allegation, the informant, the FIR, author of the FIR is saying that, the allegation that to disqualify her from the process of selection, the petitioner here deliberately produced another certificate of 2018 saying that the 2016,
This will be crime under what section of law?
my lord, should not be forgery, but of course cheating will come, my lord,
How?
because she has issued a certificate.
Cheating, come to the definition of cheating.
My lord, I'll come to
I
that.
think 415 maybe.
I'll come to that. My lord, here she has issued a certificate saying that of 2016. Now, by virtue of that, she is qualified for the post. Now, her allegation is that in order to defeat that, she has produced another certificate. Because she is the author of the certificate, she can produce any number. So this needs to be investigated, my lord. We have made an elaborate investigation
Just
here.
tell us which way it becomes a criminal offence. Assuming that this whatever you say it is correct, which way it becomes a criminal offence? It has to come, if you say it's a criminal knowledge, it has to come under certain section of law. May not be 460. Just
May
tell
not
us-
be, may not be. But however,
tell us under what section of law. Because here, just remember one thing. The maker of the certificate has not done anything for her benefit. So that is what.
My
Come
lord,
to all the definition
I
of
think,
420, 406 everywhere. You will find the wrongdoer does it for his own benefit. Here it is not a case.
my lord, here as per the FIR, it points to the fact that she has got some illegal motive to disqualify the private respondent from being appointed there.
But then this may be a different, how it becomes a criminal this offense.
Because this
She
is
might not like this thing, that restaurant number 5 to be selected.
my lord, this is a charge sheeted
Okay.
matter. Charge sheeted matter.
Yes.
During the framing of charge, they can
Doesn't matter.
They can go into that.
Charge sheeted matter.
Charge sheeted matter.
That is what I've asked,
It is
my lord.
charge sheeted.
But doesn't matter, my lord. When I am here,
I've got the charge
for-
sheet with me, my lord.
I am here quashing the
It's
FIR.
not an offense.
Yes.
Why should you?
My lord, that is one. And it's not a criteria that only charge sheet matters.
468 you
Yes.
make against the maker.
Yes.
Then in such a case you have to say she has not issued that certificate. Then in such a case also she will not have any this thing.
I understand. Just hang on. No, don't, please. This is
just
you cannot look into
No,
this.
it's my
just like
case.
that.
No, you are charge sheeted against me.
Unless until
So
there
I
is
just
an order
wanted
from
to-
the court.
Yes, no, sir.
Under the
No, I just wanted to know what section they have charge sheet me.
That's all right. He will. You can ask him. He will tell you.
I'll submit to the court.
If he is not allowing something, why? Please.
Yes,
Yes,
my
my
lord,
lord.
sir. My lord.
Since this is a charge sheeted cut, my lord, my humble submission would be the right court to hesitate about the section, my lord, involved is the trial court below, my lord.
You have seen recent decision of Supreme Court.
My
Even a matter is charge sheeted also, the court can call for
Yes.
charge sheet.
Yes.
Then we will tell you. To
Yes,
produce
yes.
charge sheet.
Yes.
And then we will see what is this. If required, we will interfere with that.
My lord, I'll
So
produce
you
this.
produce the charge sheet.
My charge sheet is here, my lord.
Mr. Guru, until and unless you make out a case, why should you pursue this kind of?
Here, my friend is there for the private respondent.
Yes. What is it? Yes. Please come, this side. Just tell her. Come, this side. Come.
No, the purpose of filing of the FIR is because that the petitioner has defamed me, and because and with the intention to declare me as an ineligible candidate by the commission.
So it will crime under what section of law? It will become crime under.
That
what
is
section?
that will be defamatory, criminal defamation.
So this case is under 468.
They have wrongly registered actually.
So this will be a defamation,
Defamation case.
criminal defamation.
Yes.
What is the law? Criminal with regard to criminal defamation. This charge sheet has been filed. You know under what section of law charge sheet has been filed?
No, man. I have not received any notice.
Let the charge sheet be produced. We'll
Yes.
just see. Let us see under what section of law it has been there. Okay. Hard. Just right. All three parties. Just. Mr. R. Guru. Standard. You are still GA, Mr.
My lord.
GA appearing for the state submits. That matter has already been charged.
It has been charge sheeted under 177. Furnishing of false. 177.
Have you received summon from the court, Mr.
No, my
Here?
lord. No.
Not yet.
Not yet.
One 177 read with section 500. Defamation, furnishing false information.
What is criminal defamation? Where do we get the definition of criminal defamation?
Section.
Come to 499.
499, my lord.
499.
How can it be termed as a criminal defamation? Can it be?
My lord,
You will have hurdles. Cannot make a thing. You see, like cannot converting non-criminal action to criminal action would be quite tough. Even 177 also, to what extent it will apply? Yes. You will have a
wisdom of the investigating officer. Man.
That is all right, but then you say like wisdom doesn't mean that you will basically drag somebody to face a criminal trial
Petitioner can always agitate before the court during the framing of charge.
What you will say? How 500 comes? How 177 comes? How, if you go by the definition of 419, how 500 comes?
Your Lordship, first of all, I'll come to the facts of the case. Lordship, 2019, I've applied for the post of state organizer.
That the fact the court
Yes.
has got. Perhaps
Yes, and I have submitted a certificate showing me that I've served as
You have
a
worked experience from 2016.
2016.
Then subsequently,
the petitioner approached the MPSC and submitted the certificate of 2018.
yes.
That certificate is a manufactured certificate.
Which one?
2018.
How can it be manufactured?
Because
There is no
it is
dispute that 2018 has been issued by her.
Yes,
That
ma'am.
is the correct certificate.
Issued
That
by
is
her.
what- that
Both the
is what-
certificate issued by her. By her.
So how
Both the
can
certificate issued by her.
how can it be manufactured? If you say manufactured, what will make it manufactured?
What she alleged me before the commission is that I have submitted a forged fake certificate before the commission. 2016 certificate.
Yes, that is so far as
the
you are
allegation
concerned.
against me.
But then see, this criminal case has not been filed against you. So there is no allegation against you. We are just confined with the petitioner now. We are not determining what allegation is against you here.
Yes.
So referring to allegation against you basically may not have any
That's
bearing.
what, it has an impact, my lord, because of my
No, so far as the fact is concerned, you may have said. But then we are not on the basis of fact. We are just more interested to know
yes, ma'am.
what criminal offence has been instituted. Even if we admit that the petitioner has a wrong intention of disqualifying you from the
Yes.
candidature, okay, then even then also, how it becomes what criminal offence?
I've made that specific allegation in the FIR also, Your Lordship.
No, that we have seen. The FIR has been read
Yes.
out. This has been read out.
Yes, my lord.
That is all right. That is okay. But then what offence is made out from there?
It's a defamation, my lord.
How? See defamation. See 419 and say, was it published somewhere?
There is one development I just forgot to tell my lord. She has been appointed now, the same post, and her appointment is under challenge. So her appointment is under challenge.
Where?
Justice Thank you court, my
There
lord.
is a writ petition filed by somebody, some other candidate.
Somebody are the candidates challenging her candidature.
That is it that on the same ground? It is on the same ground.
Yes, on the same ground. Yes, on the same ground.
Because why she have claimed that she have not issued the
Anyway, in
2016
civil matters,
certificate.
be decided on the merits, on the
Yes,
basis of the merits.
Yes,
whatever
ma'am.
it is. But then we are right now concerned about the criminality. You see, otherwise, is she under any legal obligation to issue a certificate? If a person refuses, says that I will not give you certificate, can you go and force that person
No.
until and unless a rule provides that
Provides.
certificate has to be issued?
Yes.
So whatever she has done, it is for your favor.
Yes.
Even if she says it's 2018, it is for the purpose of extending favor to you.
That's why, my lord.
She could have refused, said I will not give certificate.
But why why she have issued another certificate, my lord? Once she have issued 2016, then why issued another 2018 certificate? To disqualify me from the application of the post selection process. Because the experience demands for 3 years experience.
Then why she issued you
That's why,
2016
no.
certificate?
The criminal intention arises from them.
No, then why did she, if you question that why she issued the 2018 certificate, then the question only why she issued the 2016 certificate?
She issued this 2016 certificate based on the that I have served before the as a
And then why she
assistant.
changed it? She is not a candidate. It
She's
is
not a
not your
candidate.
case also that her daughter, son, or somebody is completing. Then
That is the reasons known to her.
then what is why somebody should do wrong?
That's why, my lord, the investigation will find out.
Investigation will not find out that.
What is an intention
Investigation
to
can
issue
only
two
say
certificates?
investigation can only say about the certificate
Yes.
and what it will prove. What can be proved by certificate? This is her signature. She is not denying.
She has
She
alleged
will
me of
support it. She
forging.
will say this is the actual certificate.
She have
But she is
alleged
the
me
maker
of forging the
if
signature.
The
ma'am.
maker of the certificate says I have issued it.
Yes, ma'am.
Which way you can dispute it? If you were to say that yes, it was basically for some other ulterior purpose, now then you have to say that what is that ulterior purpose and which way it becomes a criminal offence.
She have alleged me somewhere that
Anyway,
I
Mr.
forged
Guru,
the signature.
produce this chart sheet. We'll just see. What was the last part, Mr.? That's all right, Mr. Has already been charge sheeted. Praise that he may be allowed to. You will bring the charge sheet by way of affidavit, or you'll just furnish it?
I'll finish it. I'll flag mark it and
No, you just give a copy. If it is not very big, you can make a Xerox copy.
my lord.
You have Xerox machine in your office, I believe. Just and praise for time to produce the same before the court. Prayer allowed? When you'll do it?
I can produce tomorrow also.
So we'll not take it up tomorrow. It will come to next week.
Next week, my lord.
List this matter after a week. Be prepared on that line.
Yes,
Yes.
sir. Yes.
This is quite interesting.
Somewhere she have alleged me forging a signature.
No, that is okay. You see, we are not saying even that intent, if it is attributed, even it is accepted to be correct also.
Yes.
What criminal offence it will be?
Okay.
Obliged.
Obliged.
Second call, item number 1.
Yes.
My lord, my lord, this is the 482 petition, my lord, where I am challenging 2 order of the London Trial Court. These are order dated 29/6/2022 and 6/12/2023. My lord, before I start with the case, my lord, I just want to give a brief description about the case. My lord, this is a case under section 376 506 IPC. That is this is pending before the session judge, Southwest Castle District, my lord. That is session case number 34 of 2020. And the accused person herein, my lord, who is the petitioner, he has been undergoing trial. Now, what has happened is, my lord, the trial proceeded under section 376 506 IPC against the accused person, and all the witnesses were examined by the prosecutions, and the 313 statement also statement of the accused has already been recorded by the court, my lord. Thereafter, my lord, what happens is the investigating agency, they give a forwarding letter to the court enclosing the FSL report, and they submit the FSL before the court. Now, only questions which needs to be determined by this court is whether this FSL report can be submitted after conclusion of evidence and after statement of the accused is recorded under section 313. That is the only question, my lord, which needs to be decided here. If I can take your lordship to section 173,
subclause 8,
CRPC, my lord,
which provides for further investigation,
yes,
supplemented charge sheet.
right, my lord.
Yes. Then
Now, if I can just read out, my lord, this provision. Nothing in this section shall be deemed to preclude further investigations in respect of an offence after a report under subsection 2 has been forwarded to the magistrate, and whereupon such investigation the officer in charge of the police station obtains further evidence, oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form prescribed, and the provisions of subsection 2 to 6 shall, as far as may be, apply in relation to such report or reports as they apply in relation to a report forwarded under subsection 2. Now, when, my lord, a further investigation is done or any oral evidence or documentary evidence is found, that can be produced before the court, there is no doubt about it. This power is there under section 173 clause 8. But this power, my lord, has to be exercised within a time period. It cannot be that the final argument has already been concluded and they come up with a FSL report. It cannot be. I would like to take your lordship to some of the judgments, my lord, which I have referred. If my lord will come to page number 5 of my writ petition, my lord. I'll give a compilation, my lord, but Page number 5, my lord. Here, my lord, I am referring to one of the judgment, my lord, Honorable Chhattisgarh High Court, my lord. It says, my lord, only relevant person I am reading. Paragraph 4. Soon after the death, a mark was registered wide Exhibit P9 and thereafter FIR Exhibit P6 was registered on 2/5/2010 on the basis of the post-mortem report. In the course of investigation, case diary statement of the witnesses were recorded and the samples of vomitus remaining part of prasad consumed by the deceased and the prasad distributed to PW1 Janmati and PW2 Kamala Bai were recovered via Exhibit P5 on 3/4/2010. On the very next day of the incident, these samples were sent for chemical analysis by the Forensic Science Laboratory via Exhibit P16, which was received by the said laboratory by Exhibit P17. However, the FSL report was not filed either with the charge sheet or in the course of trial. Accordingly, the appeals were allowed and the impugned judgment of conviction and sentences set aside. Appellant so-and-so is on bail and appellant Patram Yadav is in jail. Appellant Patram Yadav to be released forthwith. My lord, may kindly come to the next paragraph, next page, my lord. That is page number 6. Paragraph 29. It says, before parting, it is necessary to issue certain directions to the prosecution agency as well as to the trial court to ensure filing of the FSL report before filing of the charge sheet or at least before committal of the case for session trial.
This is all right.
Yes.
This is observation by the court.
Yes.
But then it doesn't negate the provision of 173.
Of course, my lord, 173 power is there.
That is not
I just want to point it out that this power has to be exercised within the time frame. It cannot be exercised when the evidence has already been closed and statement under section.
Say so. This
My lord, I will take your lordship to other judgments as well.
Yes, please.
My lord, may kindly come to page number 9.
Was a law which says,
my lord,
is mandatory.
My lord, may kindly come to page number 19. Similar case, my lord.
19.
19, page number 19.
Your petition you have made it is an encyclopedia.
My lord, I have referred this judgment so that it is easy for the court as well. Yes. Here, my lord, it says, I have already underlined those paragraphs, my lord. Such filing of supplementary charge sheet to further strengthen, this is on the point, my lord, which the question my lord has put in. Such filing of supplementary charge sheet to further strengthen the case of the prosecution is permissible at an early stage before commencement of the evidence and not in a case where the evidence was completed and the case was set down for recording of the statement of the accused under section 313 CRPC. In our case, my lord, already statement is recorded. This would amount to permitting the prosecution to bolster its case when it is explicit that it has been seriously weakened by the witnesses not seeking to support the case of the prosecutions and the court below having lightly permitted the prosecution to file such additional charge sheet and to field more witnesses would result in the prosecution being given a long rope of somehow framing the accused. This practice would lead to no criminal case being completed till such time the prosecutions were certain that there was enough evidence to bring home the charge, and till such time it could indefinitely go on filing supplementary charge sheet. Hence, the rule would be followed only in the breach and seek that the supplementary charge sheet being taken on record be quashed. In similar such circumstances, my lord, the court has categorically said that supplementary charge sheet, even though in my case, my lord, this is not even supplementary charge sheet, they have just merely forwarded the FSL report to the court without following the procedure that is laid down under section 173 clause 8. They have simply dumped that FSL report, my lord, before the court. Whereas the procedure says otherwise. The entire procedure that is mentioned in section 173 clause 8 has to be followed. Now, as far as this instant case is concerned, my lord, here if my lord will call the record, there was serious doubt as regard to the collection of blood for sampling. That is of course, my lord.
These are merits. We will not go to that extent.
That, yes. Now, my lord, my only submission is, my lord, that DNA report, my lord, which investigation agency, my lord, has submitted, that is dated 30/9/2013, my lord. and was prepared after a period of 19 months, my lord, from the date of its receipt, that is 9/2/2012. Even a delay of 1 day, my lord, that needs to be explained properly. Now, this report has been prepared after a period of 19 months. And my lord, there is already on records statement by the police saying that the previous samples which was collected, my lord, that was already been contaminated. They have requested the Meghalaya police to collect a fresh sample. Now, as per the report, my lord, the report was prepared on the basis of contaminated blood samples which was collected. That is on record, my lord.
It's all right. This is, you are going to merits all those things.
My lord,
just see this.
Only one simple question, my lord, that needs to be answered is whether FSL report can be taken on record
Exactly. That is what.
after filing of the closing of the evidence, my lord.
And 313.
And 313 is recorded already.
Yes, Mr. Shulai. What you will say there?
This is your lordship.
And they have called for a fresh witnesses, my lord. They have connecting to this FSL report. That is
Definitely,
D2
then
order.
311
Yes,
will
that
come.
power is of course there, my lord.
That's
But
all.
as far as
If
the
you-
FSL
if you
report
can-
is concerned,
see, if you can show, as you have pointed out right now, the decision to
yes, my lord.
Karnataka High Court.
Yes, yes.
Okay. I do not know whether Mr. Shulai has gone through it. Or
Amit, this is your lordship. Lordship, can we see 311? Section 311 is very wide, your
At
lordship.
yes.
Plus, this is for
No, what about he is normally 311 here would be dependent upon the admissibility of the supplementary charge sheet. So just we will not go to 311 right now. Just tell us whether the decision which are synchron.
Lordship, if we go by the language, the language under 173A, your lordship, and in my humble and respectful submission, there is no bar, your lordship.
But then the interpretation of the same given by that Karnataka High Court, that you cannot do anything to prejudice the accused.
Lordship, can you
It
see?
may happen that during the trial of the courts, the prosecution finds that some infirmity remains. To cover up those lacunas, you do it subsequently.
It is not a case of.
Will it be permissible?
It is not here. It is not a case of filling up the lacuna or filling up the to improve the case of the prosecution, your lordship. Here is the case, your lordship, where a father has made his own daughter pregnant, your lordship.
My lord, we are not going into the case. Of course,
for that,
I have
your
nothing
lordship.
We are only on evidence, not only on.
For that, your lordship.
Only on question of law, my lord. When the report has already been blood samples has already been contaminated, my lord, as per the FSL Guwahati, my lord. Second blood sample was called. However, they have prepared the report on the basis of contaminated.
This will all see.
Yes.
Just right now, there is a point. Just see, like which you have projected here. That you see, like it cannot be done. Supplemented charge sheet cannot be brought into records.
Yes. Only that question, my
313
lord.
has been done. That is the only thing that which needs to be determined.
Right, ma'am.
Lordship, because 173, your lordship, kindly come to 173 again. Nothing in this section shall be deemed to preclude further investigation in respect of an offence after a report under section 2 has been forwarded to the magistrate, and whereupon such investigation the officer in charge of the police station obtain further evidence, oral or documentary. He shall forward to the magistrate a further report or report regarding such evidence in the form prescribed, and the provision of subsection 2(6) shall, as far as may be, apply in relation to such report or report as they apply in relation to a report forwarded under subsection 2, your lordship. Lordship, here there's section 173(8), your lordship, say that mention about documentary evidence also, your lordship.
Yes, that is not
Just,
with this thing.
just because
Now, only one thing is that you see, like so far
it has to be filed as per the in the manner of filing of the charge sheet. That was the just because
there is no dispute with regard to those.
Yes, just
now, only thing is the problem is with regard to that the decision of the Karnataka High.
Just a mere fact, your lordship, just a mere fact that the police has not done the thing in a manner ought to have been done, Your Lordship, whether that will vitiate the proceeding, Your Lordship.
No, police has not done anything. No. You see, like
Just
may not
because, according to the petitioner, Your Lordship, he just forwarded a copy of the forensics report, Your Lordship.
Yes.
Just because, I may say, Your Lordship,
There is no bar to do that, isn't it?
there was a
Under
negligence
73, Mr. Shulai, that is understood. That is understood.
Lordship.
But kindly just try to appreciate one thing. 173 it definitely empowers the investigating authority.
Yes, Your Lordship, that power is there.
Supplementary.
Yes, that power is there.
Okay. See, just beginning of trial, it will not mean that stoppage of investigation. They can investigate.
Yes, Your Lordship.
They can collect further this. Now, the only thing, the question which has been raised is that till what stage they can bring it? Can it be after 313?
Lordship, because
see, after you call upon one accused, explain him to evidence which are appearing against him, thereafter to bring in against, you see, further prosecution evidence. Is it
Lordship,
Not
going by the wordings, the construction of the wording in 173A, Your Lordship, there is no time limit, Your Lordship.
Exactly.
Time limit.
So that is
time
what.
limit is
See, that is what. That is
so,
where.
For just determination of the court, Your Lordship, the trial court has that discretion whether to accept or to reject it.
Supposing, go by what you say, that there is no time limit. Now evidence is reduced. Now is it that accused will be again examined under 313?
Yes, Your Lordship. Because if this forensic report is to be taken into evidence, Your Lordship, he has a right.
And then after second 313, if you find any further
Lordship, that would be too much, Your Lordship.
No, my lord, it cannot be allowed. It cannot be allowed.
That would amount to filling the lacuna or improving the case, Your Lordship.
Decision of Karnataka High Court may not be binding.
Lordship,
it will definitely have a persuasive.
My lord.
Lordship.
And it has a logic. It has a logic, definitely, that if after accused discloses all his defense by cross-examining, can you do, you see?
Because we do not, as of now, we don't know what is the stage of the case.
That is the stage, my lord.
As has been submitted my.
Yes, 313 already completed. Final argument, my lord.
Because as of now, Your Lordship,
this is 376. This is a private respondents.
Only government, my lord.
then the victim will have a right to be heard, Your Lordship.
May not be. It is not an order of these things.
Where's the FIR? FIR is not here.
Only orders.
Oh, only the order.
Two orders.
There's an order dated 6. There's an order of 29/6/2022.
Lordship, it appears, Your Lordship, that allowing the supplementary charge sheet has been allowed sometime in the year 2013. Lordship, kindly come to page 30 of the impugned order.
30.
Yes, Your Lordship. Kindly see from the above requisite. Then somewhere in the middle, Your Lordship, can you see?
Yes.
May I read it, Your Lordship?
Yes.
For the above requisite of section 311 CRPC, this court has gone through the material on record is seen to be a case where a victim of 13 years allegedly raped by the accused person with a threat to kill if the incident is disclosed to anyone. The charge has been framed against the accused person under section so and so, and it also have been recorded with the statement of the accused. It also seen as per the charge sheet so and so, the same has been submitted with a prayer to submit the supplementary charge sheet when DNA will be received, which was allowed by the order dated 1/11/2013. Had already been allowed.
No, my lord, there is no order. That is only sin.
And the DNA was received by this court by the order dated 29/6/2022. It already allowed, Your Lordship, in 2013. If we are to take the order of this,
Mr. Sinkan, give us that copy of that Karnataka judgment.
My lord, I'll have to take a printout, my lord. I'll just submit it.
Will issue notice.
My lord.
Issue notice. Hard, Mr. Soilsir. Issue notice.
let the informant also be.
Not
given the
necessary, my
opportunity.
lord.
Not required. We'll see, because this is not against conviction or all those things, you see.
Yes.
So we'll just see. For technical plea, what we'll do. Issue notice, return available in 3 weeks. Mr. Conditional line landed AG. APS. Where is AG? Along with so and so, APS for phone number. Along for
My lord, in the meantime, order may kindly be stayed, my lord, till such time, because the matter is fixed for final argument, my lord.
see what happens.
Till the time, my lord, till the time matter is
This
decided.
is the order of 29/6/2022. We have come late.
No, my lord, it has come to our knowledge.
So and so enters the PS for the respondents. As such, no for normal 40 notice is called for. You have list after 3 weeks.
Only till the time, my lord, the matter is finally. The question has to be decided, my lord. This needs to be decided. If the witnesses are already examined, my lord, it will have no meaning about this case, my lord.
No, Mr. Sinkan, you also have come late. You should have come after this thing. This DNA report was taken on record at least 7-8 months back.
It was
My lord,
allowed,
there was a hearing, my lord. The order was passed thereafter, my lord. We were allowed to file show cause. We have filed, and recently, my lord, the order was passed, and we are challenging this order, my
So
lord.
far as the other thing is concerned, that has been your latest thing is on something else. Latest order is on something else.
Now, my lord,
you basically on admissibility of that.
right now, if suppose, my lord, my lord held it that this is not admissible, you cannot take it on record at this belated stage. What will happen to the?
Then admissibility of the evidence can be argued at the final hearing also. Now, if you say this matter is pending for final disposal, is it your case?
They have. Yes, my lord. This is at the final stage of hearing, my lord.
No, then it's okay. That will not be taken into consideration. Then whatever is there, material will be decided on that matter.
Yes.
That is what.
But here, my lord,
is
what
not
has
going to
happened
pass a judgment tomorrow.
when the matter was fixed for final hearing, my lord, final argument, they have issued fresh summon to the witnesses, my lord. That is the question, my lord. So till the time, my lord.
You come with a decision. Let us see. We will examine the whole decision and we will see later.
Oblige me.